And then remember, there was some debate that was raised by my learned friend, and Justice Davis engaged with that debate about, that was under the old ANC single majority. Now there is no majority, and how does that impact? Firstly, we say that that's no answer because the court's judgments deal with majorities in general, not a single party majority. But look about what the court says in that same paragraph about minorities. It is equally unacceptable that a minority within the committee may render the motion stillborn when consensus is the decision-making norm. It would have been an easier matter for the Constitution to specify that scheduling of the motion is subject to political negotiations and so on. The point we make here is that what the Constitutional Court says in the context of motions of no confidence is that where you have the entitlement, that entitlement should not be left to an unfettered discretion from the majority or the minority, however constituted, where that has the effect of potentially breaching rights that you are otherwise granted. Obviously there, it's in terms of 102 of the Constitution. Here we say it's in terms of Section 12.3 of the Act.
Can I just ask
Yes, Judge.
As a matter of principle, when one quotes judgments and puts up legal propositions, do the facts of the case in terms of which the propositions are located matter? In fact, I was taught that in first year law school. A ratio essentially is located to the factual context. There's a very significant factual difference between motions of no confidence or private member motions and a disciplinary structure.
Yeah, I'm happy to accept that.
Do you therefore accept that when one reads these submissions that you make, you have to take that into account?
Not to the extent that it operates as a bar from not looking at how the court looks at majority, how the court looks admittedly in different...
So let me just finish my point.
Oh, I apologize.
Does it mean that if you look at the structure of what we concern now and say that's very different, how does one then read the legal propositions you're advancing?
So you asked me two questions. The first one is about whether I accept, I can't remember what that was.
Well, we'll deal with the second one. So it's just related to the first. How does one read a statement of law in circumstances where we say, well, I can perfectly understand what they're talking about in relation to a private member's motion or a motion of no confidence?
Yes.
The latter, which I know a lot about because that case started with me.
Yes.
What I'm asking you is, when you're dealing with a sort of context here of Parliament having a right to discipline its members, why would one automatically say the same principle applies?
I'm not saying that the same principle applies. I foreshadowed that the facts are different. All I said...
No, I appreciate that you said that, and I appreciate that.
Appreciate that I was saying that these different examples, EFF2, Oriani Ambrosini, and Mazibuko, all give direction from the Constitutional Court of how the Constitutional Court looks at the mechanics of majoritarian decision-making in the House under different regimes, and therefore this court cannot simply close its eyes to that analysis